What a time to be alive in America. What a time to be alive. I can't believe it. Great news. President Trump just won a huge win from, it would seem, the most unlikely of sources. The U.S. Supreme Court just handed Trump a huge win on the deportation of criminal migrants under the Alien Enemies Act of 1798. Oh, Judge James Boasberg. He's crying tears that he was not able to compel the President of the United States to turn flights around over international waters, in international airspace, and return hundreds of terrorists back to the United States. Judge James Boasberg crying tears of sorrow that he's not going to be able to hold President Trump in contempt of his petty, little, tyrannical, black-robed, inferior trial court. James Boasberg, who evidence suggests has been orchestrating the careful distribution of these court cases against Trump to his own courtroom as the Chief Justice of the D.C. Circuit. I was going to do a show on that tomorrow, but this news broke. I was actually out in my backyard relaxing for the day, a little bit of warm weather here in Colorado, and my lovely wife Emily ran out and said, "Holy cow! Look what just happened. Look what just happened. The Supreme Court, in a 5-4 ruling, without Amy Coney Barrett, just saying, backed President Trump's use of the Alien Enemies Act to summarily detain and deport TDA terrorists from the U.S., crushing underfoot the flagrantly unconstitutional meddling of this black-robed, unelected, tyrannical, inferior court judge, James Boasberg. And this follows on the heels of the Supreme Court just backing Trump in another case that I covered twice already today. The case of poor El Salvadoran Garcia, who came to America in 2011, illegally, a member of MS-13, an international gang, crime cartel, human trafficking, drug trafficking, weapons, prostitution, murder. Yep. Because the Supreme Court came down about that too today. About that too. It happened while I was doing my show today. So twice today I did shows on the national security kerfuffles, interferences, gross violations of the separation of powers doctrine under our American constitutional order. And while I'm doing the show, everything changes underfoot. Everything changes underfoot. So in the case of poor Mr. Garcia, Kilmar Armando Abrego Garcia came to America in 2011, was living here 8 years before he found himself arrested in the company of a bunch of MS-13 members, found by an immigration judge and an appeals court, an immigration court, to be a member of MS-13, received a final deportation order, somehow was still allowed in 2019, 6 years ago. Kilmar Armando Abrego Garcia received a final deportation order 6 years ago, and he's still in the country in March 2025 when he's arrested again in the company of MS-13 after MS-13 has been designated by the Secretary of State to be a terrorist organization. He's summarily deported to El Salvador, the SCOTUS prison complex, and he's all upset about it. He can't imagine how this happened. As the media tells us, he's just a Maryland father, not a high-ranking member of MS-13, which is what he actually is. And the judge in that case, Paula Zinn, on Friday summarily ordered that President Trump, under her orders, was to compel El Salvador to cough this terrorist up and return him to the U.S. by midnight tonight, Monday, April 7th, or he, President Trump, the elected Article 2 executive branch president of the United States, elected by the whole of the American people to execute our political will, that Article 2 executive branch president will be held accountable by this puny, unelected, black-robed, tyrannical, inferior federal trial court judge who America elected to do nothing but settle disputes before her. And this guy's not before her. He's in El Salvador. Well, today we got some news on that. While I was doing my show talking about it, the Supreme Court of the United States ordered that the April 4th, 2025 order of United States District Court Judge Paula Zinn to return that President Trump, in his exercise of national security authority, which the Constitution bestows entirely to him and Congress, and then Congress had bestowed their share to him, that President Trump could be compelled by this little trial court judge to act contrary to his judgment in what was in America's national interest, that he could be ordered by this federal judge to return an identified terrorist to America by midnight tonight. That order is stayed, frozen, null and void, pending further orders from the Supreme Court of the United States. And by the way, in celebration of some good news out of the Supreme Court, I'm wearing one of my official Supreme Court ties. Bought it in the gift shop at SCOTUS just this past Monday. So Garcia is staying in El Salvador at SCOTUS until further notice. That was great news all by itself. But then we got even better news. We got news on all the TDA stuff. Remember the 5 guys, TDA guys? They were on the plane to go to SCOTUS. They got pulled off. They got pulled in a detention center in, was it Louisiana? And then, of course, all the left-wing, pro-illegal immigration, anti-American NGOs and lawyers, they all got together and they said, oh, no, we have to save these guys. These people identified, classified under President Trump's proclamation under the Alien Enemies Act as being quasi-military actors of Venezuela, engaged in predatory incursion into the United States under the Alien Enemies Act, which act passed by Congress in 1798, signed by our second president, John Adams, which act gives our executive, the president, the Article 2 executive branch officer, the single individual assigned that role, gave him complete discretion in the manner of summary detention and deportation of people who fall within the scope of that proclamation of the Alien Enemies Act. Congress gave him that authority. That means the entirety of the executive authority under the Alien Enemies Act sits with the president. The only thing the people who can do that fall in that classification under that proclamation is ask to be put in front of a judge and oblige the government to put forward their claim that the person meets the classification requirements under the proclamation of the Alien Enemies Act. In this case, that the person is a member of TDA, that the person is 14 years of age or older, that the person is not an American citizen. If the government can say we have reason to believe those things are true, that person is summarily detained and deported from the United States anywhere the president wants them sent. That's literally what the Alien Enemies Act says. Judge Boasberg didn't like that. Judge Boasberg wanted to exert authority over this case, even though these TDA members were being held in Louisiana. And Judge Boasberg is in the District of Columbia. So even the due process to which these 5 terrorists were entitled was due process they were entitled to in Louisiana. That habeas corpus hearing in front of a judge where the government stands up, says, yep, we have good reason to believe they're TDA, they're 14 or older, they're not American citizens. In Louisiana. But Judge Boasberg decided, you know what? My jurisdiction, my authority as a federal judge is infinite. I can exert it anywhere in America. I can exert it anywhere on the face of the globe. I can order flights turned around, flights carrying terrorists, deported from America under the Alien Enemies Act, enacted in 1798, signed by our second president, John Adams, who defended, by the way, the Boston Massacre, British soldiers, successfully. Judge Boasberg has more authority than all of this. More authority than our Article 1 branch of government, Congress. More authority than our Article 2 branch of government, the executive branch. As one of 733 federal judges, Judge James Boasberg has infinite authority in our constitutional order, according to him. And I was planning to do a show tomorrow morning about all the ways in which Judge Boasberg is conflicted, has apparently been orchestrating all these cases into his own courtroom, all these cases involving Trump. And just about an hour ago, the Supreme Court stepped in and checked Judge Boasberg hard. Let's take a look. Let's take a look at what the Supreme Court had to say in their 5-4 decision. And that is this. Let me make this bigger. Yes, I'm a little animated, folks. Hey, folks, if you like this kind of coverage, just do me a favor. Subscribe. We're trying to get our community on YouTube to 1 million followers. Well, look at that. We just broke 176,000. So hit that thumbs up, like button, subscribe, help us achieve our goal. We can only do it with all of you. That's what convinces YouTube to share our content more broadly. Of course, if you don't like this kind of content, I don't know why you're here. But if you like me ranting and raving a bit about all the forces trying to prevent President Donald J. Trump from saving our great nation, subscribe. It's free. It's totally free. All right. So, see if I can make this bigger so it's easier to read. By the way, first reading for me too. Trump versus JGG, which is one of the 5 TDA members. They're all included in this suit, of course. And I believe this was written by Chief Justice Roberts, because he's the procedure guy. He wants all the I's dotted, all the T's crossed. Maybe he's finally stepping up. We'll see. In any case, the Supreme Court says, this matter concerns the detention and removal of Venezuelan nationals believed to be members of Tren de Aragua, an entity that the State Department has designated as a foreign terrorist organization. The president issued Proclamation 10903 invoking the Alien Enemies Act to detain and remove Venezuelan nationals who are members of TDA. invocation of the Alien Enemies Act regarding the invasion of the U.S. by Tren de Aragua, 5 detainees, and a putative class, because Judge Boasberg just created a class of every TDA member in America, sua sponte, on his own initiative. 5 detainees and a putative class sought injunctive and declaratory relief against the implementation of and their removal under the Alien Enemies Act proclamation. Initially, the detainees sought relief in habeas, among other courses of action, but their habeas would have been held in Louisiana, where they were being detained. They didn't want to go in front of a Louisiana federal judge. They wanted to go in front of a District of Columbia federal judge, maybe one who'd been prepared for them. So they gave up their habeas motion, which they were entitled to and are still entitled to. But they dismissed their habeas claims in Louisiana. On March 15th, the District Court for the District of Columbia, inferior, black-robed, tyrannical, unelected federal trial judge James Boasberg issued 2 temporary restraining orders preventing any removal of the named plaintiffs and preventing removal under the AEA of a provisionally certified class consisting of all non-citizens in U.S. custody who are subject to the proclamation. It's outrageous on its face that this judge could imagine that his authority, his jurisdiction, extends in this manner. On March 28th, the district court extended the TROs for up to an additional 14 days. The D.C. Circuit denied the government's emergency motion to stay the orders. The government, meaning President Trump, the White House, then applied to this court, the Supreme Court, seeking vacature of the orders. We, SCOTUS, construe these TROs as appealable injunctions. This is important, folks, because one of the tricks these progressive DEI woke fascists in the judicial system have been pulling is to use TROs as durable injunctions, but then claim, well, it's only a TRO, it's only valid for 2 weeks, so it's not appealable. You, the Article 2 executive branch president elected by the American people to exercise their political will, you can be hamstrung for up to a month by anyone or all 733 federal judges if we issue a TRO and don't allow you to appeal it. It's nonsense. And the Supreme Court recognizes it as such here. We construe these TROs as appealable injunctions. And here it is, folks. Here's the money shot. We, SCOTUS, grant the application of President Trump in the White House and vacate the TROs, not stay them, not suspend them. We obliterate Judge Boasberg's TROs, preventing Trump from deporting these TDA members under the Alien Enemies Act. The detainees seek equitable relief against the implementation of the proclamation and against their removal under the Alien Enemies Act. They challenge President Trump's interpretation of the act. You can read it, folks. It's only a couple of pages. There's not much interpretation. And assert that they do not fall within the category of removable alien enemies. But we, SCOTUS, do not reach those arguments. Challenge to removal under the AEA, a statute which largely precludes judicial review, citing their own Supreme Court precedent in Ludecky v. Watkins, 1948. Challenges to removal under the Alien Enemies Act must be brought in habeas. Again, habeas is where someone's been detained by the government. They have a right to be presented in front of a judge and have the government explain why they're being detained. So people are not secretly detained for lawless reasons. The Alien Enemies Act spells out the due process to which people defined in the proclamation are entitled. There is no limitless jurisdiction in any federal court. Every federal court has limited jurisdiction, including the inferior federal district trial courts. Congress creates all these inferior courts. Article 3 of the Constitution creates only the Supreme Court. Every inferior court, every other federal court but the Supreme Court is a creation of Congress, and Congress defines their jurisdiction, their authority. And guess who passed the Alien Enemies Act? Congress. And in that act, Congress set out what due process the people captured within the scope of an Alien Enemies Act proclamation, what they're entitled to. And they are entitled to due process. Here's the due process. The president defines the scope of the proclamation under the Alien Enemies Act. And if the government's arguing that you fall within that scope and you are to be summarily detained and deported anywhere the president wants to send you, you have the right to a habeas hearing. You appear before a federal judge, and you can oblige the government to demonstrate that they have good reason to believe that you do, in fact, fall within the scope of the proclamation. In the context of President Trump's TDA proclamation, that means the government can be compelled to appear in court and say, we have good reason to believe this person is a member of TDA. We have good reason to believe they're 14 years of age or older, and we have good reason to believe they are not an American citizen. That's it. The due process is over at that point. There is no more. There is no jury trial. There are no appeals. That is it, because that's the due process that Congress put in place for this purpose. And it's Congress, not the courts, that define due process. Regardless of whether the detainees formally request release from confinement because their claims for relief necessarily imply the invalidity of their confinement and removal under the AEA, their claims fall within the core of the writ of habeas corpus and thus must be brought in habeas. Here's the problem for these people. They know damn well that if they're brought before an impartial judge in a habeas hearing, it will be found that they are TDA members, they are 14 years of age or older, and they are not American citizens. It is incontestable that they are subject to summary detention and deportation. They cannot win in habeas. That's why these 5 guys waived their habeas hearing. They don't want that hearing. If they have that hearing, they'll be in El Salvador by the end of the day. And immediate physical release is not the only remedy under the federal writ of habeas corpus. The detainees are confined in Texas, not the District of Columbia. I said Louisiana earlier. Sorry about that. There's another detention center in Louisiana. The detainees are confined in Texas, so venue is improper in the District of Columbia. In other words, Judge James Boasberg has not had jurisdiction over these men ever. Ever. And this is a point I've been making relentlessly. He needs to be impeached. He needs to be driven from the bench for failure to serve during good behavior, for this grotesque overreach and violation of the separation of powers doctrine. He knew damn well he had no jurisdiction over these men being detained in Texas, but he's in the District of Columbia. He doesn't like Trump. He's acted against Trump many times in many cases. This is a political judge. That alone should drive him from the bench. He's never had the legal authority to rule on any of this. The Supreme Court continues. As a result, the government is likely to succeed on the merits of this action. You think so? The detainees also sought equitable relief against summary removal. Although judicial review under the AEA is limited, although it does exist, it's the habeas hearing, we have held that an individual subject to detention and removal under that statute is entitled to judicial review as to questions of interpretation and constitutionality of the act, as well as whether he or she is in fact an alien enemy as defined by the proclamation, 14 years of age or older. And the interpretation and constitutionality of the act has been done. It was done in this case right here, Ludecky v. Watkins and other cases. Under the proclamation issued by President Trump, the term alien enemy is defined to include all Venezuelan citizens 14 years of age or older who are members of TDA, are within the U.S., and are not actually naturalized or lawful permanent residents of the U.S. The detainees' rights against summary removal, however, are not currently in dispute. The government expressly agrees that TDA members subject to removal under the Alien Enemies Act get judicial review. They get that habeas hearing, and that is it. That is all they get. So the detainees are entitled to notice and opportunity to be heard, appropriate to the nature of the case. More specifically in this context, AEA detainees must receive notice after the date of this order that they are subject to removal under the Act. The notice must be afforded within a reasonable time and in such a manner as will allow them to actually seek habeas relief in the proper venue before such removal occurs. Again, these 5 TDA guys in front of Judge Boasberg, they were offered habeas relief. In fact, when they came to Boasberg, they were asking for habeas relief. And you know what Judge Boasberg told them? He said, fellas, I don't think you want to do that, because if that's what you want, I have to send you back to Texas, and you'll be in front of a Texas federal judge. Right now, you're in front of a D.C. federal judge, me, James Boasberg, the Chief Justice of the D.C. Circuit. I can guarantee you, you're going to get a better outcome with me than you will with a Texas federal judge. So they all dropped their habeas motions at the active suggestion and encouragement of Chief Justice of the District Court, James Boasberg. There are a number of dissents here. I'm not going to read them. I'll post a link to this in the description to the show. The dissents are from the usual suspects. Sonia, wise Latina Sotomayor, perhaps the dumbest Supreme Court justice we've ever had, but for Ketanji, I'm not a biologist, I don't know what a woman is, Jackson, Kagan, of course, and Amy Barrett. I'll let all of you read those at your leisure. I'll finish up here with the Chief Justice. For all the rhetoric of the dissents, because they're very agitated that the Alien Enemies Act is a thing that President Trump can do. For all the rhetoric of the dissents, today's order and per curiam confirm that the detainees subject to removal orders under the AEA are entitled to notice and an opportunity to challenge their removal. The only question is which court will resolve that challenge. And habeas is always in the jurisdiction where you are being detained. The purpose of habeas, as I said, you've been arrested by the government can be compelled to put you in court. The warden of your jail can be obliged to present you in front of a judge and explain why he's holding you. But it's the warden where you're being held. It's not any judge anywhere. It's that jurisdiction here, Texas. Continuing, the dissents would have the court delay resolving that issue, requiring, giving our decision today that the process begin anew down the road. We see no benefit in such wasteful delay. The application to vacate, not just stay, not just suspend, but obliterate the orders of the United States District Court, the unelected, tyrannical, black-robed, inferior trial court judge James Boasberg, presented to the Chief Justice and by him referred to the court, is granted. It's a fully operational space station, folks. The March 15th, 2025 orders granting a temporary restraining order and the March 28th, 2025 extension of that order are vacated. It is so ordered. And there we are. Good news for President Trump, good news for America. To think that America has to be saved at every step by these 5-4 Supreme Court majorities, we have to make some some systemic and institutional changes, folks. We have to stop letting the Democrats just steal elections. They're a corrupt force. They're corrupting our nation, our exceptional America. There'll never be another. If they kill this, if they kill us, there's nowhere else to go. Nowhere else to go. Preserve it, folks. Fight for it. Don't buy the propaganda of the left, the brainwashing. They always lie. If progressive fascists didn't have lies to tell, they'd have nothing to say at all. All they have is lies. All right, I'm going to take a look at questions and comments briefly. Was I sufficiently energetic for everybody? If you're on YouTube, those need to be in the form of a $5 super chat. If you're a law self-defense member, I will address them, of course, for free in the member chat. So let's see. Does the SCOTUS decision also remove from Boasberg's court and transfer to whatever court the alien enemies are held in custody? They're held in custody. Now, they're not coming back. So, law self-defense member Kansaki, what the heck is wrong with ACB? I haven't read her dissent. I'm not sure what her issue might be. I guess I will read it. Maybe I'll comment on it tomorrow. But this is my third show of today, folks. So this is what we're covering here right now. Brandon says, I love this decision. Liberals are losing their mind. I'm not sure if they're more upset that these criminal thugs can be removed by Trump or that they were wrong about the authority they claim the lower courts had. They all seem to think that even if you're a designated terrorist unlawfully in America and you're captured by ICE, that you have a right to like a full-blown jury trial before we can throw you out of the country. No, you do not. How much due process you're entitled to is a function of what the Constitution and Congress allows. And Congress says if you're a designated party under a proclamation under the Alien Enemies Act and you're not a U.S. citizen and you're 14 years of age or older and we catch you in the U.S., you are summarily detained and deported anywhere the president wants to send you. Congress explicitly gave the president that authority. Andrew says, is habeas hearing similar to a first appearance where you're formally charged? I mean, only superficially. It serves a very different purpose. Law self-defense member Will says, this should be a very useful ruling against all the other injunctions being paraded by these rogue judges. Well, remember, there's three buckets of these cases, right? There are the firing cases where Trump got a very good Supreme Court ruling just this Friday, 5-4, again, saying he's allowed to fire people. Then there are the spending, the contract cases, where people are claiming that they're owed money by the government. All of those should be in the federal court of claims, not in federal district court. I think that's where we're going to end up with those. And then we have the third bucket, the national security immigration cases like this one. Friday's Supreme Court decision should largely settle all the spending cases. And this decision should certainly settle all the Alien Enemies Act cases, which granted only covers TDA, but it certainly sends a signal about where the majority of the Supreme Court is coming down on this. So yes, very helpful. Andrew says, sounds like a slight change. They can't just sweep them out of the country like they did last time. These guys were entitled to a habeas hearing. They asked for a habeas hearing. They were in court, in federal court for a habeas hearing. They dropped it because they know habeas is not going to save them. And by the way, we don't have to do these habeas hearings individually. We could bring 100 people into a courtroom and the government could say, Your Honor, here's a list of the 100 people present. We have good reason to believe each of these people is a TDA member, 14 years of age or older, and not a U.S. citizen. Bam, you're done. That's all your due process. See you in El Salvador. Yes, the third show of today. Luigi says, why are all the suits in federal district court? Aren't the court of claims just as liberal as the district courts? They might be, they might not be. They're not full-blown federal judges. So it's not quite the same. And their authority is much more constrained than what federal judges can do. Will says, in what other court would the judge helping the defense, well, the plaintiff actually, win their case be tolerated? The judge is a judge, not defense counsel. Yes, the judge is supposed to be impartial. It says so in the U.S. Code of Conduct for judges. The code that defines serving during good behavior that was created by the Article 3 judicial branch itself says judges must be impartial. You're not impartial if you're helping craft the arguments of one side against the other. Denver says, question, what might dictate where the illegals are held at any point in time as compared to where they're arrested? Well, that's at the discretion of the executive branch of ICE and the various Department of Homeland Security detention facilities. Where do you think they're going to send them? They're not going to put them in a detention center in the District of Columbia. They're going to grab these guys, put them on a flight, and get them someplace where they might get an impartial judge. Zakuza says they hate these rulings because it proves Joe Biden could have done this at any time. Yes, of course, he could have. But he didn't want to do this. He not only didn't want to do this, he wanted the opposite. Joe Biden kicked the door open on illegal migration. We saw that from the chart I often share with you. Tens of millions of illegal migrants. And those are just the ones encountered at the border. They don't count the ones flown over the border by Biden and dumped into red state cities all over the country to try to make them permanent blue state jurisdictions. All right, that looks like the member stuff. Let me take a look at the super chats. And then I have my dinner sitting next to me, waiting for me. But I serve our community first, folks. I hope you know I love you all. Don't forget to subscribe. Please subscribe. We're trying to get to a million followers. We just broke 176,000. We're looking for a million. We can only do that with your help. All right. Jennifer, $10 super chat. Thank you very much. Says, Muffin Rando asks if you could please call him Boasberg. Love your content, Andrew. Oh, there. I'll put that up. Thank you very much. I really appreciate that. $5 super chat. Sudes Lounge, $5. Says the full DC circuit overturned the Harris firing stay. Yeah, I saw that. I talked about that in the last show. Just means Trump has to take that to the Supreme Court too, where they should lose. And April Gonzalez, a new member on law of self-defense. That is very much appreciated. So let me see if there are any others I need to address. And if not, I'll go to dinner. All right. It looks like that's it. Great news. Great news for President Trump. Great news for America. Bad news for TDA. Great news for the CCOT prison in El Salvador. And they'll get more payments from America to house the terrorists we've evicted, summarily detained and deported from America. Another super chat just came in. Old combat vet, $5. Notice that the flood of hordes are into Western Christian nations. Yeah, because we create value. Where are they going to go? The third world? We, Western Christian nations, create value in quantity. So they come here. Just like raiders always go to where the money is. Because, is it Willie Sutton said, asked, why do you rob banks? He's like, well, that's where the money is. Why do all these terrorists, international gangsters, murderers, thieves, traffickers, why do they come to America? That's where the money is. We created that wealth within a system designed by our founders, the great nation. the greatest nation, the United States of America. All right, folks, I'm going to go ahead and wrap up. Thank you so much for joining me. I'll keep this one a little bit short in comparison to what I normally do. Have a great evening, and I guarantee you I'll be back at 11 a.m. Eastern Time tomorrow morning, again with more exciting stuff to talk about. Subscribe. Hit that thumbs up button, and I'll see you all in the morning. Have a good evening. Until then, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.